It's not really a good deal financially, is it? And that's where you come in terms of the level of warning, I suppose.
There'd be a debt owing even once the property was sold.
It's awkward, isn't it? Well, in some cases it's awkward, other cases they believe they have the right to the inheritance.
Are there any other relatives that can support you? To be honest, that's usually met with laughter. So.
We've all experienced in the last year rising interest rates and the impact on loans. Hello. Today I'm going to be chatting with my colleague Pippa Bavington, who is one of the partners at Giles Wilson, specialising in all aspects of probate, trusts and elderly client advice. We're going to be talking about equity release and what that is and the type of situations that really need a little bit more thought and advice. Hello, Pippa.
Morning.
Thank you for coming on the show with me. I'm fascinated to speak to you about this because I know you've got a long experience in it. So just to explain that equity release is a special type of mortgage available for the over 55s, comes in various forms, but the principle behind it is that it releases the equity in the property at a time when most people do not have an income to sustain a normal mortgage. So in other words, we're sitting in perhaps valuable properties, particularly in the southeast where we're based, but our cash flow situation is not quite as comfortable as we would like it to be, and it want to do something about it. Can you explain to me a little bit more, Pip, about the type of scenarios that you come across and why people do go for these type of mortgages?
So I think it's worth mentioning that we use the word mortgage, and that is strictly speaking accurate, but sometimes clients don't see it that way because they sort of say, well, I'm not making monthly repayments. And that's one of the main things about this type of loan, and one of the main benefits, as you say, because they don't have necessarily always a large monthly income in which to pay capital or interest repayments. So get a whole range of circumstances why someone takes out an equity release mortgage. One of the most common reasons is home improvements. Particularly much elderly clients, they don't want to move house, they don't want to downsize, they want to stay in their home, but often want a new kitchen or even purchasing a new car or extensions. And that's when they say, well, I don't have the savings, but I've got all this money in the house that I don't necessarily, I know that I don't want to move again during my lifetime. So why not use what's there, that
yes.
asset that's otherwise tied up?
But it's not really a good deal financially, is it? And that's where you come in terms of the level of warning, I suppose, you need to give clients.
That's it, exactly. And equity release mortgages still have a sort of taboo, I suppose, because historically they were not well regulated. They are well regulated now. We have the Equity Release Council, of which we're a member. Just to make people aware of what exactly they're entering into. It's not financially a good deal, but that's not to say that you should just let the finances govern your decision making, because actually on a practical level it can be very helpful.
So can you explain to me a little bit more why it's not a good deal, really? Because it seems to me a great deal, that if you've got a property worth 500,000 and a small income, borrowing 50,000 against that would seem, quite sensible.
Yes, on the face of it, it absolutely is. And it's expensive, but it won't be expensive during your lifetime. So that's where the benefit comes in, because the interest that arises on this type of mortgage, I say, is not usually repaid. I emphasise usually because some clients do repay the interest, which is not how they're designed, but it's cumulative. So it builds up and it rolls up very quickly. So whereas we might think 6% interest sounds okay, actually if you're not making repayments on that, it's a huge amount to pay at the end.
So is it 1 year 6% and then the next year it's interest on that accumulated interest? Is that how it rolls up? Just to explain a little bit more
So quite often the actual equity release mortgages are very clear now, and this is because of the extra regulations. They will show the example of how the interest rolls up. And I believe that sometimes, depends on the lender, but you can see it, they'll show, okay, this month you'll pay X, Y, Z, and then the following year it will be this much. So it's always increasing. It's not like a standard mortgage that generally decreases over time.
No.
This mortgage will grow. So you might take out, or a client might take out £50,000 mortgage, and then in 10 years' time that could be £60,000-70,000 mortgage.
Yes. So obviously, for those, there's your client or our client is the person taking the loan. But if you were the child of someone in that position, or someone who hopes they may inherit one day, that you may have some interest in what your parents are doing, which sounds, it's awkward, isn't it? Well, in some cases it's awkward, other cases they believe they have the right to the inheritance. So how does that play out when you're advising your client who comes along and says, I don't want to tell my children because I don't want them to know that I'm borrowing this money against the house because they expect they're going to inherit it, but I'm terrified of my gas bill, so I'm going to borrow money to put double glazing in. Is that a typical situation that could happen?
It could. Fortunately, it doesn't. So I've been, advising in these type of cases for many years now, and more often than not, it's a really good point because it's a point to do general estate planning as a family.
Yeah.
Sometimes, so more often than not, when I discuss this, and it is one of the things the Equity Release Council expects us to discuss with clients, have they spoken to potential beneficiaries about the impact of inheritance? My clients will usually say yes, and my children or beneficiaries just say, well, crack on with what you want during your lifetime. I don't necessarily need to inherit from you. There are two other things that I see quite regularly. One is people taking equity release mortgages for inheritance tax planning, which might sound a bit bizarre, but if you've got a very valuable property, even if you haven't got a huge amount of savings, your estate could still be subject to inheritance tax. So that's tax when you die. But if you're reducing the value of your property during your lifetime, it can mitigate that.
Yeah.
And the other situation is that parents regularly take out equity release mortgages to help a child during their lifetime.
Right.
So a sort of advance.
Help them with a down payment on a property themselves, or if they're in debt, etc. Yes. And so there's a couple of points that I'm thinking of. We've all experienced in the last year rising interest rates and the impact on loans of that. But also we have lived through 20 years plus of property prices increasing. Are we relying upon interest rates being low and property prices increasing too much, do you think? And how much advice to people, how much should people be thinking about that when they are thinking, fine, my house will go up in the 20 years that I've got left of my life and the interest rates will be fine?
So a lot of those aspects are discussed with the client and the mortgage broker or financial advisor.
Right.
Because obviously as solicitors, we cannot advise on the specific product.
No.
It's once usually the client has found the product that they would then come to us for the detailed advice. And we're sort of the second field of defence, if you like, where they've had the advice from a broker or financial advisor. They get their mortgage report and then we just do a sense check with the client.
Yeah.
One of those things is, appreciating that the value of the property could decrease and the impact that would have. In most instances, the equity release being taken out is quite modest. Yeah. So quite often it's at least £350,000 property and they may be taking £50,000. And also one of the additional protections, which again is part of the Equity Release Council thing, is a no negative equity pledge.
Yeah.
What that means is that historically, someone could take out a mortgage of this type, and when they died, the mortgage would be more valuable or more expensive than the value of the property.
So there'd be negative equity at the end.
There'd be a debt owing even once the property was sold. That can't happen anymore.
No.
You could have a nil balance in theory, but again, usually... and I think lenders are more cautious now because they want to make sure their money comes back to them at the end of the loan period. So usually the amount being drawn out is relatively modest, sometimes with an option to draw out further funds. So sort of a reserve. Someone might say,
so it's really important, isn't it, the Equity Release Council's regulation and the lack of protecting people against mis-selling. So get a good mortgage advisor and product to begin with, then come to a solicitor such as yourself, Pip, who I know you work very closely on these with our property team, because there's two parts to an equity release arrangement. There's the normal, in inverted commas, remortgage of the property, making sure it's a good security for the loan from a property perspective. And then there's the ancillary advice that you give. And I know that you do always look at the individuals or the couple's will to make sure that the taking of this loan, the impact that will have, as you say, you go through, do their beneficiaries know? In fact, would a beneficiary prefer to say, Mum, Dad, I've got loads of savings, here's 50 grand, have this, I'll get it paid back when you pass away and I don't want interest on it, so that's absolutely fine. That's always an option. And then there's also the impact on any benefits that they might have. So if you've got somebody, say, with pension credit or any other means tested benefit, presumably you talk to them about the impact of that capital sum dropping in their account could have.
Yeah, so there's, I describe sort of the two-pronged process, the transactional side, which colleagues in the property team deal with, and then the holistic planning, which is a great opportunity as a legal MOT to look at wills, power of attorney, benefits. Again, the benefits point is something the financial advisor should have discussed with them first, or the broker, but it's something I raise with them as well. It's quite unusual that that's an issue. In terms of whether they can get a loan elsewhere, again, that comes into the financial advice aspect, but it's something we just briefly touch upon. Again, that sense check, just to say, have you considered downsizing? Have you considered a conventional loan, depending on the amount? Are there any other relatives that can support you? To be honest, that's usually met with laughter. So quite often they've already considered these things, but we're just making sure that they have. Where warnings have to be given, I don't really like to use that word, but it's appropriate, I think, is do they realise the limitations on what they can do with their property? And by that I mean, can they move house? Of course they can, but can they take that type of mortgage with them? Can they do certain things in their wills if they're looking for trust and things like that? That gets a little bit trickier sometimes.
Yes, and I suppose also it is an opportunity for you sitting there with the clients face-to-face, or when I say face-to-face these days, I do equally mean virtually, of course, but you can assess the situation as to whether in fact they're being persuaded by a family member to borrow against the property. I know I've seen that occur, and that delicate, difficult conversation that you might have to have.
I did have a client recently who approached me and said, my daughter said it might be a good idea to do X, Y, Z. And I said, well, let's discuss it. And actually the reasons, and I think it was innocent in this case, but the reasons why both the daughter and my client had considered it were not applicable. They were worried about inheritance tax, which they were covered by allowances anyway. But it's a good opportunity for a general review. Quite often people don't have wills in place, or they're really old, or they haven't considered powers of attorney, which actually are more closely related to this type of mortgage than you would initially think.
And I think the point you make about inheritance tax planning is, as well, there's a lot of misunderstandings, understandably, as to the inheritance tax limits these days, and people are fearful that their families might have to pay tax, and sometimes you're able to, when you do your legal MAT, explain to them that potentially that they won't have to. So what other type of specific advice do you find yourself giving clients in that age range when they come along to make their wills? I know that the holistic conversation that you have is so valuable in terms of people disclosing who their beneficiaries are. For example, I've spoken with clients and they sit there and they talk about their 6 lovely grandchildren. They want to leave them £10,000 each, perhaps in their will, maybe a little bit more to the grandchild that's got special needs. And of course, a big flag goes up with us at that point. And I know that you specialise as well. One of your specialities is in disabled persons trust, which sounds a very big word, a very big phrase, but actually it can impact on a £10,000 legacy to a grandchild who's got learning disabilities, can't it?
Yeah, that's all sorts of. It's one of the reasons I really like equity release work, because it's an opportunity to really help a client across a broad range of things. So when we look at their wills, the example you gave of potential vulnerable beneficiaries, sometimes it could be that a child or a grandchild is even living with them. So it's understanding the impact of that and that kind of mix of their will, an equity release mortgage and a vulnerable beneficiary. So it can be a disabled or vulnerable beneficiary. And that covers a broad spectrum of conditions or things that challenges that people are living with. So it's really a good chance to explain to the client what provisions might be suitable in their will.
Yes.
One of the other things that regularly comes out is, I think I touched upon it already, is that they are actually taking out money to help a beneficiary during their lifetime. So it's considering the impact on their will. If, say, they've got 2 children and they're taking equity out of their property to help, their son buy property, and that son is maybe buying with an unmarried partner, so much legally goes into that, protecting that investment, if you like, in the son's property, balancing the inheritance with their daughter in their will. It's broad scope of work.
So it's about, advancing on their entitlement in the will, isn't it? From maybe the £10,000 legacy that I've mentioned, which is quite a big legacy actually for grandchildren to receive, but it's a good example because it crosses into the means tested benefits level, and that's why I use that figure. In some means tested benefits, if you've got more than £6,000 in your bank account, you will not then be entitled to the benefit. The other aspect is, as Pippa's explained, the fact that if you've got a beneficiary who is never going to be able, unfortunately, to manage their own money, then that could trigger the need for a court of protection application as well as loss of benefits, and something that could quite easily be avoided by the will being drafted in a different way. But then there is this advance on a legacy. So, in a different scenario where grandparent is the one with a nice little bank account with some savings in, and grandchild wants their first car, and grandparent says, well, would you like your legacy now? Then you can buy the car now, but you won't get it when I die. How do you, if we're told about it?
That's the key, isn't it? And actually, I often have to explain to the client why I'm asking the sort of questions I am during an equity release equity release meeting with them. It's not, sheer nosiness. It's actually part of my professional obligation or duty to understand their family, their personal circumstances, so that I can advise appropriately. So in that instance of, I want to make an advance on inheritance for one child or grandchild, then we can always draft into the will whether that's to be taken into account on death, to rebalance on death, if you like. Sometimes it might not be the case if they say, well, actually, I know that side of the family really struggle financially, so I'm doing this in addition to...
So does it always take a new will, or can a note be put with the will that money's been advanced?
Ideally, it should be a new will. The problem with anything informal is enforceability, and I always sort of say if anything is left ambiguous, it can lead to disputes. So it's better to have it watertight. That's kind of best practice advice. Again, depends on the family dynamics.
Of course, everything does. Back to that word holistic. And you mentioned earlier about if people have got a relative, or not necessarily a relative, but somebody living in a property with them, and the issue of dependency. So in terms of the equity release mortgage, that's very often going to be one of the conditions of the mortgage, isn't it? That probably they can't continue to live there when the person has died unless they're able to take out a new equity release mortgage in their own right against the property. But there is also the impact on the distribution of the will, isn't there? The sale of the property and everyone getting what they're supposed to get in the will when somebody may have acquired a right to live in that property. So we have this difficulty, don't we, if we have a more vulnerable person dependent upon the person making the will who is unaware that they could be creating a problem for when they die for the other members of their family.
And that's our job as lawyers, is to warn of risks or potential risks, and always think, what's the worst case scenario here? It's cheerful, but actually it's to avoid those situations.
Yes.
The lender will insist on a waiver being signed by any adult occupier, and the lender will not care if that adult occupier is vulnerable or not.
No.
So that's for us to think about what provision, because actually if you've taken out this type of mortgage, and this goes back to what I said about it limits what you can do with your property to a certain extent, because you cannot then say, when I die, I want XYZ to stay in the home, because the lender will want their money back when you die.
As you say, they're not there facing the family dynamic, the situation that we see straight up.
Yeah.
And this is an issue that can so often be resolved if we know about it early on. It's not just with equity release, as I say, it's with will drafting generally, that quite often I've found that a family are supportive of the setup, that child A is living with parents for whatever reason. Quite often child A would be giving the majority of care perhaps to the parents. But unless this is dealt with appropriately at the outset and the arrangement is established, there's all sorts of problems later down the line. I mean, I deal with a lot of care home funding, means-tested care home funding, i.e. elder parent needs to move into, sadly, nursing or residential care, and the local authority want the house to be sold to pay for that care, but you've got child A living there. Now, if the advice is taken early on about those arrangements, there's usually solutions, more difficult to put right later on. And similarly, child A, you may think as a family, well, we'd really like them to be able to live there for all their lifetime or a certain period of time. But again, it's got to be in the will, hasn't it?
It's got to be in the will, and much of this comes down to practical considerations as well. You've got the law, which, a will, which I can say, this will is legally valid, as in the words on the paper are valid.
Yes.
But will it function in practice?
Yes.
That is such a huge difference.
Yes.
And part of it is encouraging our clients to face those difficult realities about future planning, rather than sort of that temptation of, I'm not going to think about it today because it's too overwhelming. And it's to guide them through that and let them know what the options are, or as a minimum, practicalities. Is there a sibling that could look after that person, even temporarily? And then the property is sold and they might get a bigger percentage to help them buy a replacement home. Or is the money going to go into a special trust for them? So that they can be supported for the rest of their lifetime.
And
So
I know
it's all
you
about
write
planning.
excellent letters of advice, Pip, and that, I think, is also another really important point, is that the advice is put in writing, it's kept there. There's no surprises for anybody when the person dies. We know exactly what's going to happen, because when somebody loses a loved one, the last thing they also want is a surprise about some other element of it. But, I mean, I'm afraid we've run out of time today, but we've covered quite a lot that I'm sure is very interesting for a lot of people. So thank you so much for coming on, chatting with me.
Enjoyed it. Thank you.